Hello, everyone. I welcome you all to today's roundtable discussion by the Legal Cluster at Center for New Economic Studies. On the panel, we have with us today Manav, Yasir, Chaitanya from the Legal Cluster. I welcome all the panelists today and thank you guys for joining us. Today, we are going to critically look at the various personal laws of different communities from a gendered lens. That is, the intersection of family law, what we call family law in India, with gender equality and inclusivity. We'll try to probe the discrepancy between the normative ideals of family in law and the actual experiences of the varied gender identities within and outside the heteronormal and at times heterosexist framework of marriage and family. Family laws in India regulate the most intimate aspects of our lives, such as marriage, divorce, parenthood, and inheritance. While some of them are secular and apply to all citizens, regardless of faith, others apply to individuals belonging to certain religious or certain particular communities in specific. So, keeping that in mind and keeping in mind the serious conflict over legal pluralism reflected in the simultaneous presence of personal laws and uniform codes in our constitutional aspirations and present explicitly in our constitution, today's discussion will take a deep dive into these intricate underlying issues pertaining to autonomy, equality, and a mere recognition at the face of several varied personal laws present in India today. So today, let's start the discussion with a rather broad question first. So my first question is, what do you guys think? How does the interplay between societal norms and religious customs impact the enforcement of gender equal provisions within Indian family laws today?
So, as you know, like we as a society have grown, we have passed a lot of gender neutral laws, but the enforcement still remains kind of murky. As we all know from the news, that instances of gender violence and people who have been given the gender just laws, they don't, they are not realized in the society. For example, societal expectations. It has been so long that we have lived in this patriarchy. So the society has a general attitude towards women. This in India is especially towards women. For example, in 2005, the amendment was passed that inheritance would be equally shared between the co-partner's sons and daughters. But it's still not realized because I have seen this justification a lot of times, that people spend a lot of money on the marriage of the girl child, but they don't give them any inheritance. They say whatever we were to give, we have given that in dowry, or we have given that in the marriage, and the property is just for the son. And then society, this was a part of societal expectations, but then religious expectations are also there. For example, when a wife leaves for her husband's family, she's supposed to go to the another family, become part of that other family. So she has given up all her rights, all her inheritance from the previous family, and she's just supposed to get anything from the husband's family. But then in Indian law, that's also very murky, because wives of husbands cannot become the karta of the family, or they, even if they receive the uh, um, inheritance, it's not realized fully because they have to share it with other people, right? So I think in order to get a full enforcement of the gender just laws, we first have to educate people. Just passing the laws does not mean that they will be realized or they'll have any real impact, because society will always have these informal barriers. So the education part becomes very important. So when men realize that they are actually equal to women and not superior, that's how the real change will come. Yeah, that's all from my part.
Um, Thank you, Chaitanya. That was quite a holistic answer you gave. I mean, I completely agree that the enforcement definitely remains murky, and there are issues in law. It's just like black letter law, which is sort of realizing a kind of equality on paper if it's present there or in customs in coming to if we talk about personal laws, but its implementation, the mindset of the society, the egalitarian approach which an individual should take is something which is lacking in a society, and that's very well put by you, and that lays down the ground for us for our further discussions. So with that in mind, I'll go on to the next question. How have judicial interpretations of child custody laws under Hindu family law evolved to accommodate gender disparities and determine the best interest of the child?
So the essence regarding guardianship laws and custody laws basically lies in the concept that minors, since they are like, because of the tender age and everything, they are incapable of deciding for themselves or caring for themselves when their parents are not there or when their guardians are not there. So because of that, they kind of require protection. So this is this is their responsibility, which then falls upon the state, which they act as the pater patriae to ensure and make sure that the children are protected and to ensure that the children's best interests are kept at heart. And so this basically forms the foundation behind custody and guardianship laws. So when we take a look at these laws in the context of Hindu codified law, so the Hindu Minority and Guardianship Act, the HMGA of 1956, basically governs the rights and the responsibilities regarding guardians and custodianship for Hindus in India. So this was enacted at a time when lots of other uncodified Hindu laws were also being enacted and formally codified into law. So since it was enacted at a very just after independence, so there were obviously some patriarchal norms and ideas which underlied the provisions and the other sections beneath the legislation. So the primary legislation which I want to take a look at is Section 6, subsection A, which basically says that the natural guardian for a boy or an unmarried girl would be the father, and that after that it would be the mother. So this basically implies that during the lifetime of the father would be the natural, the primary guardian of the child, and only after that can the guardianship be then claimed to be given to the mother. So this provision has been frequently misused by fathers using their children as pawns in situations of domestic violence and separation and divorce cases to like mentally put pressure and destabilize their partners and their spouses. However, the courts, through various judgments, through a catena of judgments, both the Supreme Courts and High Courts across the country, have basically held that this provision, which gives father the primary right, the main right regarding the natural guardianship of their child, are not absolute, and there are like many exceptions and many cases in which it would not be so. So I take so the primary case law which I wanted to take a look at, and which was a very significant case law at that time, was obviously the Geeta Hariharan versus Reserve Bank of India, in which the petitioners basically challenged this provision only, Section 6, subsection A, of violating Article 14 and 15 of the Constitution, saying that it violated the equality clause and all. The court in that case, Supreme Court, did not strike down the provision as being unconstitutional per se and like being violative of the Constitution, but instead they said that the word after, which appears in Section 6, does not mean that it must be read as being in the absence of, and clarified that in the absence of the father is basically if the father is not physically or mentally there during the lifetime of the children, like he's not there, like he has totally abandoned his child, or he's mentally not capable enough to look after his child. And also in cases where he has does not have any care for the child, and in many other cases the court has basically said that it cannot be read as being meant that only after the lifetime of the father can the guardianship be given to the mother, even in those specific certain cases. So like if the father was absent during the child's life through indifference, or as I said before, mental inability or physical incapacity, or even if there was any kind of arrangement between the parents, the mother can be considered the minor's natural guardian even during the lifetime of the father. So even though the Supreme Court did not strike down the provision as per se being unconstitutional, however, they found, based on the technicalities, they found a space for women also, the mothers also being given the right for guardianship, even though the father is present and even though the father is alive during that lifetime. So there are even more examples which we have seen, which high courts and Supreme Courts have laid down. So, like there was this case of Surinder Kaur Sandhu versus Harbakh Singh Sandhu, in which the court denied custody to the father due to his criminal conduct, thereby underscoring the importance of the moral character of the parent also, and if they're morally fit to look after the child. So we can basically say that while the court's interpretation, while the court in Gita Hariharan and these subsequent and previous case laws has broadened the grounds for mothers' right to guardianship of their children, the court fell short of discharging the constitutional mandate of ensuring equal rights for both the parents, for both the spouses, for the women and the men, and failing to treat the mothers on an equal footing. Like they just, based on a technicality, found it as an exception rather than laying down it as a specific rule. So, however, we can see that the decisions that the father's rights are not totally absolute. Like there are certain cases where women can be given the right over the father also, and there have been these parameters have been evolved in the courts regarding moral conduct, the behavior of the parties concerned, including the guardian's abilities, the presence of other family members, and various other steps which the court has laid down to determine whether or not guardianship should be given. So the courts over the time has have moved from a patriarchal guardianship system to a framework in which the child's welfare is put foremost and their interests are taken at heart. So there has been quite a lot of progress, but there still remains a lot of progress to be made.
Thank you, Manav. I completely agree with you. I mean, um, as you pointed out, what the court has at least done for us is that on one hand, they've tried to sort of balance gender equality, keeping gender equality in mind, and on the other hand, they have always given priority to the best interest of the child, as which is very clearly visible in Gita Hariharan case. And in that particular case, I think court went on to also interpret constitution, certain articles of the constitution in a very broad ambit. CEDAW, UDHR, all of those things were cited, and I think that's I think court also has that power in cases of the best interest of child to do those things, because I think we have a secular law which applies in the cases of child custody and adoption through to all the religious communities in our country, because there is a present of a secular law which has been codified. And I think that makes a sort of things easy for court to dive a bit into the person aspects of different religion. And definitely the court has been very activist on that, and things are getting sort of better in that. But moving on to the next question, how do you guys think, how does the lack of legal recognition for sex marriages under Indian laws, such as the Hindu Marriage Act or the Special Marriage Act, impact the rights of the LGBTQ plus individuals? And what reforms would you think would be necessary to ensure equality and inclusivity of those individuals?
Yeah, I think uh, with a system that is very specific to India, and even otherwise, if you look at South Asian countries, our family laws are heavily influenced by, be it religious customs and societal values. But above all, is the question of societal value and what the society accords as to be correct and what not to be correct. If you look at the question of same-sex marriages, this is something that has been very much contemporarily present in the Indian discourse on family law, with the Supriya case also going to the Supreme Court, and then the parties having come out very in a very disappointed way from the Supreme Court. In a way, I would say that the Supreme Court failed a majority of its population when it said it could not grant those kind of rights. So, in specifically in India, everything is so closely linked with that particular aspect of marriage that actually all the rights, for that matter, of any sort of association that two unconventional people in an unconventional setup would want, is determined by marriage, right? So in anything from the right to live together in a legally recognized manner, or be it the right to share a single bank account, to receiving your partner's to cremate your partner if when they're deceased, or when your partner is abandoned by their abusive family. So these things, all of these things are determined by the very fact of marriage. So legal recognition of marriage is something that has always been a source of this flow of this bundle of rights. Because what is marriage? Marriage is in a very in a very conventional setup. It's just a bundle of rights over each other that you enjoy through either a contract or a promise to the other person. So the question is really of the legal validity of same-sex marriages. In such cases, you see that obviously same-sex couples can live together, because India is a country that allows live-in relationships, and however, this recognition only extends to a conventional family living together. It does not extend to queer people. For instance, if there is a straight couple, like a cis heterosexual woman with a cis heterosexual man living together, if they adopt a child together, they can, possibly one of the persons can adopt a child and go ahead with that, and they would eventually be recognized as a in the societal aspect of it, they would be recognized as a full-fledged family. Similarly, the DV Act would apply on the for the wife's benefit, or the various other rights that flow with that. However, if a queer couple is living together, if they want to adopt a child, some way, if they want to cheat the system, they want to adopt a child. One of the two persons will have to adopt the child, but that would obviously, just to say that that is something that they can rightfully do is no joke, because of the fact that when you go to adopt a child, there are various compliances that you need to fulfill, and one of the key compliances is what the society thinks of your association. So, keeping that aside, if we speak strictly of what the rights they have, one of the persons can possibly adopt the child, and they can, socially live as a family, with both with both the partners raising the child as being their own. However, in the question comes in, with the aspect of inheritance. If the partner, who is not the adoptive parent, legally speaking, if that person dies, what happens to the assets, to the property, to everything that they've acquired over their life? What happens to that? Because of course, in India, we deal with two sets of laws. There is succession, there is, interstate succession, and both work very differently. One is determined by a religion, the other is possibly not as heavily influenced by it, but yes, in the case of, for instance, Muslim law, it is. So the property does not go to your spouse, to the primary caregiver, to all these people, to your children, but rather it would end up with possibly an abusive household. There was this paper that I was writing, for which I had interviewed this lesbian couple who has had such an association where they had a child, and the person who's not the adoptive parent comes from a very abusive family, and they do not want to go back to their biological family, and they're really worried about, and they were the primary breadwinner of the family, and the others partner did not work, and they were really concerned about what would happen to their property once they die. Would it go to the child that that partner had adopted or not? So sadly it would not, because the interstate succession laws, and the succession laws of, because they come from the Hindu community, so the Hindu laws also apply to them. So majority of the property would devolve to their biological family, which is in fact the abusive family that kicked them out when they were, I believe, 19 or 20 years old, and then they had to figure out their own life, build a life for themselves, get a job, get a house, and finally they get to live with their chosen family, to say the least. And even today, they cannot think of, that those assets devolving on to, their chosen family. So this is something that is heavily influenced by the concept of marriage. Now, if this couple had the right to marry, they would have the right to for this property to devolve upon their wife, or whatever spouse, upon their children, all of these things. So this entire conundrum of marriage, the reason why we were pushing for marriage so much in the Supreme Court, of course, there is a lot of criticism that has come from within the queer community itself, because marriage is a patriarchal institution. Yes, we totally agree. It is a patriarchal institution. It's the most oppressive institution on this planet, but it's still the institution that gets you practical set of rights. And those practical set of rights lets queer people determine their lives in, for the better. And if this is something that we need to, of course, there is no force that can make you conform to certain things, but yes, if there are certain things that give you practical application of your rights, it is something worth having, especially in a heteronormative world, where the least we can have is to have our chosen families and make sure that they are safe and we're also kept safe. So this is the reason why we were pushing for marriage equality all through, that for you to have a proper family that is legally recognized, even a civil union. But the Supreme Court really let us down on that. But that is still something that is in consideration. There is a review petition. Let's be hopeful for it, but let's also not be a little too hopeful about it.
Thank you, Yasir. That was a really detailed and a holistic answer. And definitely, I mean, if we start rejecting the argument that since marriage is a patriarchal or heteronormative sort of institution, then so is the so that every aspect of our lives, right? So is the institution of like the idea of universities, the idea of education, everything is colonial and everything is patriarchal. That doesn't mean that we let go of those privileges, because it's an inherent right, and with marriage comes a set of rights, as you rightly mentioned. And the problem is that in today's time, in today's India, the idea of marriage is very heavily sort of driven by majoritarian religious idea of what a marriage should look like. And with that comes how the idea of rights should also look like. And that eventually also affects the decision of the court, wherein the court ends up saying that this is not our domain to intervene, this legislative domain. And the court is very, very nicely abstains themselves. There is a huge cycle and this tightly knit idea of how a marriage, how an institution of marriage should look like, as you mentioned. But what we have to sort of figure out is that what is the way forward? Is it UCC which will give us the way forward in sort of diverting these personal laws and getting into more of an egalitarian kind of society, or is it reforming the personal laws itself, or is it, as you said, the idea of a chosen family, the idea of a more sort of inclusive queer future wherein the queer individuals have the right to choose their family and choose their set of rights. So that is something which will take us time to evolve through, to get through. But yes, moving on to the next question. And this will be the last question for our discussion today. So, guys, what do you think are the principles guiding the Shariat law on divorce and spousal relief? And how do these touch upon the broader discussion on gender equality? Anyone can go ahead.
Is it okay if I go first?
Yes, please, yes, please.
Yeah. From whatever limited knowledge I have of the Shariat, and also being somebody who comes from the community that practices the Shariat, I think there is, there's a very uncomfortable debate about Shariat and gender equality in especially in India, with a lot of majoritarian values springing up, questions of UCC, or potential UCC that will exclude and strip off Muslims of their rights on, conjugality and inheritance. I feel that, it's something that's just been made to be uncomfortable, and it was never so, because Shariat and Islam is inherently a very egalitarian concept by itself. If it's just that over the generations, it's I mean, not to blame a specific gender, but yes, men have held such strong control over religion over the decades, be it any religion for that matter. But yes, Islam in particular, I can speak of, because I come from that community and I've lived through this, that men have held control so strongly, and they've made sure that their position is so heavily dominant within the religion, that everything, all the rights are determined by what they would want. And therefore, the progressive limitations that were imposed upon the rights of women, from, what erstwhile was envisioned in Islam, how the Quran mentions humanity, never mentions gender, does not mention any sort of disparity between the genders. But how after the death of the prophet, this entire concept changed suddenly, as gradually the Khalifas passed away. The Khilafat came into the hands of men who cared only about the political influence. Women scholars were removed; they were not allowed to put out any scholarly works of any kind, as opposed to the time of the Prophet, when his own wife, was one of the biggest scholars of Arab, and people from across the world used to throng to listen to her. And she used to lecture about women's rights. She used to lecture about the rights, the egalitarian rights of all communities, black people to people from different races, people from different communities, rights of minorities, religious minorities also, according, contrary to what the popular belief in India is, that Islam is a very sectarian religion and does not allow religious minorities to exist, and so on. So, I see that from the lens of the Islamic feminists who've put out their works and who've actually tried to bring back those egalitarian tenets into Islam and into Sharia, to make sure that, the laws are actually what they were meant to be. But that movement is yet to reach at least South Asian countries, because it's something that is growing in Turkey, it's growing in different countries around that, Azerbaijan and other countries. But this is something that is very difficult to come into countries like India and Pakistan, because again, the clergy is heavily dominated by the male-centric view, and therefore the rights of women are heavily curtailed that way.
Yes. Before I go in, anyone else want to sort of come in and say anything?
Yeah, so
Yeah.
principles of gender equality, I believe equality also comes with it the notion of freedom, right? Like ability to choose. And I think in
Yeah.
India, that has been the case, especially with the judicial interpretations. For example, to talk about maintenance, a Muslim woman can choose from the protection of women on divorce, Act 1986, and she can choose from BNSS, Section 144, I guess. So I think this freedom is very important because it allows people to conform to their religion, but also to go out of it if the need be. So if there's a conservative woman who would like to live by what the Shariat law says, the Indian legal system allows that, as well as to go through the route of CRPC or BNSS, and take all the advantage of faithless laws, gender neutral laws. But uh, I think that's the beauty of gender equality, because the Indian legal system provides you with a choice to either to conform to your religion or to go out of it and avail the civil remedies which are presented to all the faiths. So yeah,
Yes. I completely agree with both of you guys. I mean, first of all, as I think Yasir rightly pointed out, that there is a very misconception at this time that we associate a particular personal law with a particular kind of sort of an idea that's regressive or that's more progressive. And I think the saddest part is that the courts and the judgments have also said that, which sort of then feeds on to this idea and literature out there because you cite those judgments, right? And eventually, if you start using that as a citation, as a literature, then that idea, that perpetuation of that particular idea will still continue for generations to come. And and as Chaitanya pointed out, I think, and from deriving from Chaitanya's point, I guess, the way forward is also having a more of secular laws for us, but that again should not be at the cost of the religious freedom of different communities. Because if you see in matters of divorce, the Islamic law, the Holy Quran says that divorce should be the last resort, but then that should not be at the cost of violence. If there is violence, if there is inequality, if there is some sort of like very pressing issue between the marriage, then divorce should be considered. But that has been then interpreted by the courts. If you look at the Shariat judgment, the courts have interpreted that divorce is the last resort, and then divorce is something which will only touch upon because the Quran says it's not good. So this kind of wrong interpretations have been there when the court has taken the position of a high priest and tries to impose their idea of what a non-codified religion should look like. So that still needs to be sort of rectified, definitely. So this by this we come to the end of a roundtable today. Do you guys have anything else to add? Yes, Yasir, please go ahead.
Just on the question of divorce in the Quran, I think this is also something that's very important. I'll quickly address it. That divorce in Islam, the understanding that why divorce is considered to be the last resort is also because of the fact that there has been a general consensus among not just jurists that are men, but also feminist jurists that reconciliation is not actually a bad thing. And the
Hmm.
way Islam takes takes the question of divorce and calls it the last resort is to have this sense of reconciliation, that that is the reason why there are two right ways to divorce, and then there is another one wrong way of divorce that has been also outlawed in India, but that's a different question altogether. The law on it is hilarious, and it's funny, honestly, the way the Indian Parliament has, without any sort of legal acumen, come up with that law. But the other two, Talaq-e-Hasan and Talaq-e-Ehsan, which provide a 3-month period to reconcile, is something that is, I believe that is the correct way to divorce, to actually take into consideration what just happens, not only to the man in the family, but also the wife, the way she would be treated at the end of those 3 months. So that is also something that needs to be taken into consideration, that why we call it the last uh, resort, that of course reconciliation is of primary importance, and otherwise the way the courts have interpreted it over over generations is just uh, very different from what it was envisioned in the Quran and so on. But yeah, that's just something that I quickly wanted to add, that reconciliation is actually very important in considering divorce.
Yes, definitely. Thank you, Asid, for that addition. And yeah, that's true. Reconciliation is very important in the Islamic law, and um, but that's not for the fact that because it's the strict idea of sanctity of marriage, which the courts have misunderstood, as you rightly said. So yes, that's very true, and I think it will take the judiciary also, and I think it's also problematic also because then you see these judges also have their own backgrounds. If you look at Justice Gajendra Gadkar, he belonged to a Brahmin family. So all the judgments he gave during his time was very, very Sanskritized version of what a Hindu law should look like. So, and he himself, because he himself was a Sanskrit scholar. So whenever a judge also presides over these personal law cases, their background, their study also influences of how they interpret these personal laws, because most of them are not codified, and that's then becomes very problematic. So that's true. And with that, I guess we have had a really good and holistic discussion today, and we have covered a lot of topics. And I again thank you, all three of you, for joining us today. And I'll also just add on that our team, all of us, Yasir, Chaitanya, and Manav, they have also authored papers on the same topic that we discussed today, and it will be live on our Nickel and Nine website very soon. So please do go and check out that. And thank you so much, guys, for joining us.